Friends, now moving on to the modern categorization of public policy, from tradition to modern, I think just to give you an idea about how uh, the courts have a right to intervene and decide whether a contract is to be enforceable or not. While the general categorizations and the traditional continue to be there, the modern categorization, one can view issues under the Competition Act of 2002. Friends, prior to the Competition Act of 2002, India had a legislation called the MRTP Act of 1969, Monopolistic Restrictive Trade Practices Act. And let's assume prior to 1969, what was there? I think what was there was very clearly the judicial pronouncements of saying, look, contracts that try to create monopoly in a market, and that definition of the market could be entire India, it could be one state, or it could be one kind of a territory. Those actions are not in favor of public interest. And public policy clearly understands and says if there is a monopoly player, it is going to exploit the market. And how will it exploit the market? The market exploitation by the monopoly player would be that he can create artificial scarcity of the commodity. Right? He can create that kind of artificial demand. This is definitely possible by a monopoly player, and history has seen that kind of artificial demand being created. Second, you'll also notice that the monopoly player can rig the price. He can determine the price, when to release the goods, what price to release the goods. And he would probably result in an exploitative kind of a market. Now, it is not good for any kind of market situations to actually promote and have monopoly player. Now, we have to understand this. In India, for a large number of years, while we did not look at, say, liberalization, right, privatization, and globalization, uh, a lot of services from the government were actually the only services that are available to citizens. So the government was a heavy monopoly player. But remember, the government is of the people, by the people, and for the people. And we followed a socialistic pattern of governance. And in socialism, the government is not only going to govern, it is also going to provide you essential goods and services. So we adopted socialism in the constitution. The government took over its role, or rather seriously viewed itself as not only a government of governance, but a government of business and providing essential goods and services to the citizens as well. Anyway, that probably has changed post liberalization and globalization, and probably that was the reason that there was a need to replace the MRTP Act with the Competition Act of 2002. We replaced the MRTP Commission with the Competition Commission. That is also something that we did. However, the fact is, remember, monopoly is a problem, right? Contracts that make monopoly or create monopoly is also a problem. So when two companies are given in the market, let's assume that company A and company B, one has 55% market share, the other has 45% of market share, right? There are only two players. Now, in India, there are a lot of these sectors, or a lot of these areas where there may be only just two players, possibly, unless you have the third player coming in, right? Now, if these two players decide to merge, amalgamate, right, and they create one entity, that would be an absolute monopoly. That's a very dangerous situation for not only the economy, but also consumer interest, but also national interest. So you don't want monopoly contracts or contracts that create a monopoly. This is point number one, if you go by the MRTP legislation of 1969. Second, monopolistic restrictive trade practices. Restrictive trade practices. Friends, go by the principles of the Constitution. If you read Article 19, 1 of the Constitution, Article 19(1)(g) says every Indian citizen has the freedom of trade, occupation, and business. You have that kind of freedom, right? Any contract that restricts that kind of a freedom will be not only violative of the Constitution principles, because the Constitution is a public document, it lays down what public policy is. The contract that makes that restrictive trade practice or tries to bring that restrictive trade practice into effect will also be considered as void. Now, restrictive trade practices, friends, are quite a lot, because market strategists, or those who try to create market share for a product or for a company or for a service, they come up with a lot of ideas of capturing the market. every company that wants to come into the market wants to capture the market share. The higher the market share, higher is the profitability, higher is my dominance, and higher is the restrictive trade practice. So most companies try to monopolize, literally. When I say monopolize, friends, it's not necessarily it should be 100% market share. It should be the dominant market share. Right? Now, let's look at Competition Act. Okay, so this is enough to give you kind of a background of why public policy in these are relevant and prevalent. Now, the Competition Act 2002, does it have any business with contracts and agreements? This is the first question that everyone would want to ask. Friends, for that, I would request all your attention to Section 3 of the Competition Act. Now, Section 3, friends, very clearly states that anti-competitive agreements are void. It's a declaration. So you find the declaration of void agreements not only in the Indian Contract Act, additionally you will find the declaration under the Competition Act of 2002, and do not forget this. It is the Competition Commission of India that can declare certain kinds of agreements as being void because they violate the Competition Act of 2002. Right? Anti-competitive agreements. Now, what are anti-competitive agreements? Right? That's something that we should try and understand first. Now, let me just show you what this is under Section 3 of the Competition Act. From Section 3(1) of the Competition Act says no enterprise or association of enterprises. Now, these are association of builders, association of cement manufacturers, association of software manufacturers. No enterprise, single entity, or association of these enterprises, or person or association of persons shall enter into any agreement. Please note there is a clear prohibition over here. This is the statement of public policy through a legislation. And the courts are duty bound to implement the same in respect of, please note, no agreement in respect of production, supply, distribution, storage, acquisition, or control of goods, or provision of any service which may likely cause an appreciable adverse effect on competition within India. If you enter into any such agreement that is likely to cause an adverse effect on competition in India, such agreement shall be void. So one must be asking questions about what are these kinds of agreements? How do they look like? Right? Because are they public policy and why are they not in public policy? So let me give you one example. So there's this concept under competition law called the tie-in sale agreements. Okay, tie-in sale agreements. They're very interesting ones. So tie-in sale is like this, friends. If you decide to buy MS Office, I'm just giving you an illustration without any intention to defame any entity, association, or any individual. Please note that is a disclaimer. So whatever we have used in this course are just illustrative in nature. Right? Many of these companies, they do what is known as bundling of software. Ask me what that is. So tie-in sales are where a fast-moving product in the market is sold to you because it's a fast-moving product, there is a lot of demand. But the company also has another product which is slow-moving. Rather, it's not moving sometimes. So what does the company do? It bundles these two and gives it to the consumer forcefully to buy. Okay, so the consumer has to not only buy MS Office, but he has to buy Internet Explorer as well. There is no choice. You can't divide it. Right? So once I put MS Office in my system, it is only Internet Explorer that is also going to be put in my system. I cannot put mozzarella because it is all bundled and given to me in one package. It is not divided. It is not priced differently. Now what this does, it will clearly kill mozzarella. Mozzarella will be out because mozzarella does not have a basic Office software. So it will kill competition in case MS Office decides to bundle the software and sell it to you. Is this or such kinds of contracts to be encouraged in the country? Does it defeat competition? Is it against the purpose? Because remember, friends, there are small companies that will come up with small software. It may not compete with MS Office always. I can come up with some app. I can come up with some kind of a software add-on product. These are small companies. They should also have a space in the market. Everything in the software space cannot be dominated only by one or two companies like Intel or Microsoft or Google. Right? So these can be considered, friends, as anti-competitive agreements. Right? You have to understand this. And most importantly, friends, there is another interesting concept called refusal to deal. Okay. Now, what is a refusal to deal? There are some multiple cases on this. I think, if we take a course on competition law, all these cases will be interesting cases for us to study. But for contracts, let us just understand what we must do in agreements and contracts and what is prohibited by law. So, just to give you that example. So, refusal to deal is also very interesting, friends. What happens is, let's take automobile companies. Now, automobile companies, one thing, I don't know if you know this, they make more money in service rather than in sale. Yes, ask me how. When you take an example of, say, Maruti, okay, as an illustration, what does Maruti do? Maruti comes up with Maruti genuine spare parts. Genuine spare parts. See, every car is a assembly of components, correct? With a Maruti badge name. But there are component manufacturers who support Maruti. They make these small components which go into a car and the car is assembled and given to you. Now the component manufacturers look for Maruti, right? They are all individual companies. They will be making small components including batteries and other things. Maruti enters into an agreement with them very clearly. It is what is known as exclusive supply agreements, and they tell these component manufacturers, please note, you will not sell this component to the external market. No, you will exclusively only manufacture for us. You will only sell it for us, and we'll be your sole buyers, and this is the price at which we'll buy. Now you will say, of course, sir, that's logical. Yes, it is logical, especially when intellectual property is there. If it's Maruti's design and that is what someone is manufacturing, only they can give it back to Maruti and nobody else. Fine. This is great. This is the justification of these companies to make these agreements. But what is the impact on the market and the consumer? Do you know that? What is the impact? The impact is, friends, if I buy a Maruti car and tomorrow if I have to service the Maruti car, if I need one component to be replaced in that Maruti car, do you know what I have to do? I have to go back to Maruti. Only Maruti will give you genuine spare parts. Otherwise, if you go outside, maybe you will get some Chinese spare parts which are not authentic and it will affect the performance of the car. So, Maruti very clearly with this dynamic agreement approach has forced consumers to come back to the company for all kinds of services. Please remember, sale of a car is a one-time contract. But servicing the car for 10 years or 15 years is a regular contract. That is an income. That is a positive contribution to the company's profits. Can this be considered to be anti-competitive? Now, please note, these component manufacturers cannot, please note, that is the condition of Maruti, cannot sell those components in the open market. Now, what does this do? You must be saying, sir, tell me, how does it affect competition? I'll tell you how it affects competition. Friends, earlier days, I remember, if I had an ambassador car or a Fiat car, okay, I could repair that ambassador and Fiat car with a local mechanic also. I could go to a local. I need not go to ambassador's service station or Fiat's only authorized service station. All local engineers or service even on the highway, you will find everybody saying, "Sir, I will repair your ambassador car. I can replace the air filter, that one, this one." Why? Because they were getting components freely from the market. But today, by this action of Maruti, Maruti cars cannot be serviced by any other person. So, in the service of car industry, Maruti has killed its competition. There is no other competition to Maruti. Only it's Maruti alone that has been created for monopolizing Maruti services. These kinds of agreements, friends, are susceptible to the challenge of public policy, susceptible to the challenge of being anti-competitive. Right? This is where probably the Competition Act has a role to play. Because I think in the service industry, there is to be, what does competition do? Anyone? What does competition do? Competition, friends, gets the best service. Because there is competition, you can compare A service to B service. Now, can you compare Maruti service with any other service? Yeah, you can compare with Hyundai as Hyundai car, but that's different. On the same car, can you really compare? Are there two service providers? You can rate A versus B? No, you can't. Point one. Two, if there are two service providers, one will give you better quality and better price also. Competition gets the best from competitors in terms of price, in terms of goods, and in terms of services. Competition is good for the market. Competition is good for consumer interest. Competition is good for citizens' interest. Competition is good for national interest. So it is India's public policy to have competition in the market, right? So I think to that extent you will understand and appreciate the fact that anti-competitive agreements are void for the simple reason is because they have an adverse effect on consumer choice. Consumers need choice. And unless that choice exists, citizens and national interest is not going to be promoted. And hence, you will appreciate that such kinds of agreements are not to be encouraged, they have to be curbed, there are to be intervened, and such contracts are to be held to be void. Now, did such kind of principle exist? Yes, they did exist. So, if you evaluate common law cases and some of the cases in India, even before 1969, I think the judges were very clear. They did not want anti-competitive agreements to be enforceable. Right now, you have a separate legislation that covers every aspect. It gives details of every other situation. But in early circumstances, all of these were given to the judges to actually determine what is public policy in such kinds of contract. Right? Now, you'll also notice, friends, there is a very interesting component called predatory pricing. Friends, predatory pricing is very important. It's a market behavior and a contract in which you will be surprised, friends, that you will actually get a commodity below cost price. Yes. Let's take one instance or an example just to look at predatory pricing. Can an airline sell you air tickets at at 2 rupees or 200 rupees? Can they? Well below the cost price. Why will they do it? Are they doing charity? So why do airlines give you well below cost price? Because that would be a suspicion of what we call as predatory pricing. Predator. Predator, have you seen Predator? They wait for the opportunity to dominate, to kill, right? Till then they're very patient. So predatory pricing is a concept, friends, where a new entrant to the market, a new person in the market, how does he capture market share? Let me give an instance or an example. Again, for illustration purposes, please don't take it in terms of any personal, defamation or other things. See, there were quite a few companies in the telecom space. We had Airtel, we had Vodafone, we had BSNL, and Aircel, right? These were some of the companies that existed in the telecom space before Jio entered into the market. Now, when Jio entered in the market, I'm sure all of us will recollect that Jio started giving free connections. 3 months, 6 months. They said free, 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 free. Mobile set also free, connection also free. This is nothing but kind of a predatory behavior. Kind of, right? It's not necessarily it was because it was held to be fine. Now, a company, a parent company, when it comes into a new market, it can support that pricing. It can say for 6 months, we'll give it free because we'll cover the cost, right? So let's take some kind of a median like this, okay? First 6 months, I give you free, okay? Most people from Airtel join Jio. Why? Because it's free. So I get the market share, I get all the customers on my roll for 6 months, right? Then after the first 6 months, once I get all the consumers on board, slowly I'll start increasing the price. Right? Now, what was lost in the first 6 months will be recovered in the next 1 year, or probably in the next 2 years, where I'll make more profits than what I lost in the first 6 months. This is nothing but predatory pricing concept. There could be agreements where people are selling below cost price, and that is a suspicious agreement, and that agreement can also be considered to be anti-competitive. So there are several such factors, friends, which have to be scrutinized as not being. See, you may say, sir, isn't it public policy that people are getting below cost price, they're getting free, and so on and so forth? We can always say that. But remember, friends, look at the intention. Look at the long-term implication. Once you look at the intention and the long-term implication, you will clearly come to this conclusion that they are not healthy for any economy, and such agreements and contracts should very clearly be regulated.